So good morning, everyone. Um, Welcome to our webinar, our employment webinar on the future of non-disclosure agreements. This morning, Nick and I are going to talk about future of NDAs and also going to touch on the latest from the Employment Rights Bill. We'll be talking for around half an hour, I guess, before looking at any questions that have come in. Please can you put the questions in the Q&A box rather than the chat box, as we might miss them if they go in the chat box. So please put them in the Q&A box. If you have any technical difficulties today, please check your Zoom settings in the Zoom banner. Leave a message in the chat box for technical issues, or alternatively try disconnecting and rejoining the session. So the session is being recorded, and we'll send out a copy of the slides and the recording in the next day or two. Okay, if we move on to the overview. I'm going to be looking at the Employment Rights Bill and the direction of travel on NDAs. Nick is going to do what I think is the heavy lifting and then run through the NDA provisions in the Employment Rights Bill and the practical implications they raise for employers. And as I've said, we'll pick up questions from the Q&A box at the end. So please pop the questions in as we go along when they occur to you, and we'll try and get through them at the end of the session. Before I set off, I thought it would be helpful to explain what we mean by NDAs in the employment context and go into a little bit of the historic background. So for HR professionals and employment lawyers, NDAs usually crop up when a dispute is being settled via a settlement agreement or a COT3. NDA is a catch-all term for the provisions in the agreement which restrict an individual's ability to use confidential information, talk about the circumstances leading to the settlement, talk about the fact of the settlement and the terms of the settlement, and make derogatory comments about their employer or their employees. For many years, these sorts of clauses were fairly absolute and relatively short. So, for example, up until around 2018, it wouldn't have been unusual to see a clause which was something like this: the claimant and the respondent shall keep the existence and terms of this agreement and the circumstances leading up to termination confidential, except where disclosure is to HMRC, required by law, or their legal or professional advisors or immediate family, provided they agree to keep the information confidential. Now, all this began to change following the scandals involving Harvey Weinstein in the US, when it became clear that people had not spoken out about their treatment because they were fearful about breaching NDAs they'd signed when settling litigation. This led to Weinstein's activities remaining hidden for much longer than they should have been. Pressure began to build in the UK with the Me Too movement, and Parliament began to look into how NDAs have been used in employment disputes and their role in protecting serial discriminators and harassers. The Women and Equalities Committee of the UK Parliament launched an inquiry into NDAs in the workplace in 2018. This investigation focused on the use of NDAs in cases of harassment and discrimination and other forms of misconduct, with a particular emphasis on whether such agreements were being used to silence victims and prevent them from reporting incidents. The committee's report recommended significant reforms to the use of NDAs, including making it clear that they should not be used to prevent individuals from reporting criminal activity or raising concerns with regulators. Also in 2018, the Solicitors Regulatory Authority published a warning notice regarding the potential misuse of NDAs, particularly in relation to situations involving harassment, discrimination, and other forms of misconduct. And the key points from the SRA's warning letter were that the NDAs should not be used to prevent individuals from reporting unlawful activity, including criminal conduct, and they should be clearly drafted so individuals understand when they can report issues to the authorities. The SRA also warned that solicitors must ensure that individuals signing NDAs understand the full implications of the agreement. This push towards transparency meant that the sort of clause I read out earlier needed to be significantly amended so that the limits of the provisions are clearly set out. This led to clauses becoming much longer, setting out in detail when individuals can speak out. So hopefully that sets the scene a little around NDAs and we're going to come back to talking about them in more detail shortly. But first, I'm just going to touch upon the latest developments in the Employment Rights Bill. So if we move on to the next slide. The government had hoped that the bill would get royal assent in September and published an implementation roadmap with the bill's provisions coming into force in April or October 2026 and some in 2027. However, the royal assent has been delayed because the House of Lords has suggested a number of amendments on a number of occasions, sending the bill back to the Commons for reconsideration. So as the slide said, the most recent House of Lords debate took place on the 17th of November. And again, the Lords made a number of amends, sent the bill back to the Commons. So the Lords will have to give way to the Commons eventually. But the net effect of parliamentary ping pong, as it's called, is that the bill is unlikely to get assent until December. It's not clear at the moment what impact this will have on the implementation roadmap. So a quick run through of what the amends are that the Lords want to see. The first is a requirement that employers contact zero-hour workers after each reference period to explain their right to a guaranteed hours offer and give them the option to decline instead of automatically issuing the offer. The second is including a statutory definition of seasonal work, allowing tailored treatment for employers whose staff needs fluctuate predictably during the year. The third is retaining a qualifying period for unfair dismissal rather than the day one approach favoured by the government. Fourth is a requirement for trade unions to give new members a clear, active choice about contributing to political funds rather than being defaulted into contributing unless there's a subsequent opt-out. And finally, retaining the requirement for at least 50% turnout in industrial action ballots before strike action can lawfully proceed, rather than removing the turnout threshold altogether, subject to future ministerial consideration. So given the government's majority and the importance it places on the bill generally, it seems unlikely that any of these amendments will be adopted. But as I said earlier, the net effect of it going back and forth is delay. And I'm sure you're aware when the bill does receive royal assent, much of the detail around how it will be implemented is subject to future consultation and secondary legislation. So leaving the Employment Rights Bill behind and moving on to the NDAs and the next slide. This sets out the direction of travel for NDAs over the past year or so towards much more regulation, often including bans on the use of NDAs in certain circumstances and in certain sectors. So in August 2024, the SRA warning notice that I mentioned earlier was updated, reminding solicitors that misuse of NDAs may be a breach of their regulatory duties. In July 2025, the government expanded the scope of the provisions in the Employment Rights Bill, and that's what Nick is going to talk about in more detail in the next few slides. Also in July, the Public Sector Exit Payments Guidance was revised, and this applies to central government and arm's length bodies. In addition to Treasury approval for payments, severance payments over £100,000, there's now a requirement for Treasury approval for any settlements containing confidentiality provisions. On the 1st of August, the Higher Education Freedom of Speech Act came into force, and this prohibits registered higher education providers from entering into NDAs relating to misconduct complaints involving sexual misconduct or bullying and harassment of any sort. And from the 1st of October, under the Victims and Prisoners Act, NDAs are unenforceable if they prevent a victim of crime or someone who believes they're a victim from reporting a crime or seeking advice or support. And on the 22nd of October, the DfE Academy Trust Handbook was updated, and this relates to everyone working in the schools academy sector, and requires that confidentiality clauses in staff severance agreements require prior DfE approval and must not impede whistleblowing or regulatory disclosure. And finally, on the 27th of October, one of the provisions proposed in the Victims and Courts Bill extends the provisions in the Victims and Prisoners Act so that NDAs are void if they prevent disclosure of criminal conduct or responses to it to anyone, not just to certain specified bodies. So as I said, the direction of travel in this area is one of continued limitation and restriction, particularly in the public sector and education sectors. In both central government and academy schools, it seems that most confidentiality provisions relating to severance payments will need some form of approval from the Treasury or DfE, and it's unclear at the moment how that will work in practice. So I'm now going to pass on to Nick, who will look at the proposals in the Employment Rights Bill, and those, of course, have an impact on all employers in all sectors. So over to you, Nick.
Thanks, Michael. Good morning, everyone. I hope you're well. I'm going to be looking at the specific provisions, as Michael has said, in the Employment Rights Bill that relate to non-disclosure agreements before looking at some of the practical implications for employers. As Michael has illustrated, we've seen that some sectors have already been subjected to a greater degree of restriction when it comes to the use of NDAs. The Employment Rights Bill absolutely continues that trend. Clause 24 of the bill will restrict an employer's ability to enforce NDAs which prevent workers from making disclosures relating to harassment, discrimination, and failure to make reasonable adjustments. As Michael has explained, this is quite a late addition to the bill. It was first proposed by a government amendment and agreed by the House of Lords in July 2025. The Department for Business and Trade's impact assessment of Clause 24 states that the government's aim is not to reduce or ban the use of NDAs in appropriate circumstances. It suggests the government supports the right of businesses to use NDAs to protect sensitive business and commercial information, trade secrets, and other confidential data, although some of the sector-specific guidance does not necessarily bear that out at the moment. Instead, the government states that it is seeking to prevent employers from misusing NDAs to silence individuals about misconduct and inappropriate workplace behaviour, with the ultimate intention of changing business culture to reduce harassment and discrimination. The amendments are intended to allow workers who have experienced harassment or discrimination, as well as those who have witnessed or who have knowledge of it, to speak up. And the bill seeks to achieve that aim through Clause 24, which will insert a new Section 202A into the Employment Rights Act 1996. This will make any provision in an agreement between an employer and a worker void to the extent that it prevents the worker from making an allegation of or a disclosure of information relating to harassment, discrimination, or failure to make reasonable adjustments. So this will cover NDAs in any agreement between an employer and a worker, including employment contracts and settlement agreements. The restriction will also void provisions which prevent workers from making allegations or disclosures relating to the employer's response to harassment, discrimination, or failure to make reasonable adjustments. This reference to the response of an employer is designed to capture things such as failures to investigate an allegation and detrimental treatment of workers who have raised allegations. The wording allegation or a disclosure of information is also important. It means the restriction covers disputed claims, not just proven cases. So even if an allegation was investigated and not upheld, a worker could still talk about their experience and how it was handled. Employers will not be able to enforce confidentiality in those circumstances. The other thing to note is that we're talking about workers here. The restriction will apply to agreements between employees and workers, but regulations may potentially extend that protection to independent contractors, the self-employed, and individuals undertaking work experience or training. The Department for Business and Trade's impact assessment states that Clause 24 will only void the part of a contractual provision that seeks to prevent allegations or disclosures related to harassment, discrimination, or reasonable adjustments. So if a confidentiality provision covers matters beyond harassment, discrimination, and reasonable adjustments, then the rest of the provision will still stand. The government has confirmed that non-disparagement clauses will also be void under the provision to the extent that they limit a worker's ability to speak out about relevant harassment or an employer's response to it. The references to harassment, discrimination, and failure to make reasonable adjustments here are references to those things as they are defined in the Equality Act. Harassment has a few different definitions. It includes unwanted conduct relating to a protected characteristic, which has the purpose or effect of violating dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. Harassment also includes unwanted conduct of a sexual nature, which has the same purpose or effect. And harassment also includes less favourable treatment that results from a person's rejection of or submission to unwanted conduct of a sexual nature or that relates to gender reassignment or sex. The reference to discrimination here is to direct discrimination, indirect discrimination by association, and discrimination arising from disability. And the reference to failure to make reasonable adjustments is the failure to make adjustments to avoid substantial workplace disadvantages experienced by those who are disabled. One thing to note here is that the Equality Act contains another claim, victimisation, which is not expressly covered by the restrictions on NDAs in the bill. Victimisation occurs where someone is treated detrimentally because they have brought Equality Act proceedings or raised Equality Act allegations or supported someone else in bringing proceedings or raising allegations. So this gives a slightly misleading impression that NDAs could still be used to prevent workers from talking about victimisation. However, victimisation is likely to have been left out of the restriction in the bill because it falls within the scope of the employer's response to an allegation of discrimination and is therefore already covered by the restrictions on NDAs in the bill. The final thing to note here is that the provisions ban NDAs relating to harassment or discrimination suffered by the worker who makes the disclosure my apologies. The provisions ban NDAs relating to harassment or discrimination suffered by the worker who makes the disclosure of harassment or discrimination, as well as harassment or discrimination suffered by another worker of the employer. So the provisions therefore ban employers from enforcing NDAs which prevent disclosures by workers relating to discrimination or harassment that either they or their colleagues have suffered. There's then a carve-out in the bill which confirms the ban on NDAs will not apply to something called an accepted agreement. This is an entirely new concept, and unfortunately at the moment we don't have much clarity in relation to what an accepted agreement is. The definition of and conditions for the existence of an accepted agreement are going to be set out in future regulations. And a little bit more about this is contained on the next slide. The government has confirmed it will undertake a consultation on what amounts to an accepted agreement. The expectation is that an NDA will only be an accepted agreement where the worker themselves requests confidentiality, which may happen where the worker wants closure or reassurance that the issues that have arisen will not be the subject of future discussion or publicity. The government's materials and comments suggest they may be considering adopting something similar to the Irish model or Ireland Plus. Restrictions on NDAs were introduced in Ireland in November 2024. The Irish model allows NDAs where they are requested by the worker receives mandatory independent legal advice in writing before signing the NDA. The independent legal advice is provided at the reasonable expense of the employer, and there is a cooling off period which would allow the worker to change their mind. The government's consultation will also give consideration to whether an NDA must be time limited and would only therefore apply for a temporary period. We also don't know yet for certain whether NDAs in ACAS COT3 settlement agreements will be subject to the same restrictions or whether they will be accepted agreements under the bill. The final thing to note here is a provision in the bill which will allow future regulations to be passed to make NDAs in accepted agreements void if they prevent allegations or disclosures relating to harassment or discrimination to a specified person, for a specified purpose, or in specific circumstances. This means that even where NDAs are validly made in cases of harassment and discrimination, by capturing them in an accepted agreement, workers would still be permitted to make disclosures to certain prescribed people, such as medical professionals, to get the support they needed. Again, the government will consult over the types of individual a worker may speak to, for which purposes and in which circumstances. So the key takeaway from these provisions is that they will significantly reduce the scope to use NDAs to prevent staff talking about harassment and discrimination. They are reflective of a cultural shift towards transparency and accountability. And where NDAs relating to discrimination and harassment are used, confidentiality will cease to be employer-led and will become a worker-led choice. Now, one absolutely key question in all of this is, when will these new restrictions come into force? And although the government has published an implementation roadmap for the Employment Rights Bill, the roadmap predates the amendments which introduced the provisions relating to NDAs. So the roadmap doesn't mention NDAs or confidentiality at all. So the implementation timeframe is currently unknown. It could be any time after the government's consultation on NDAs has concluded. But putting that uncertainty to one side, there are several things that can be done now to prepare for these new provisions, and we've sketched some of these out on the next slide. The first thing is to undertake a review of how confidentiality provisions are currently used in your existing documentation. This should capture not only settlement agreements, but also contracts, policies, and internal procedures. Once we have a clear idea of where confidentiality provisions are used, consideration can be given to whether those provisions need to be updated in anticipation of the introduction of the restrictions we have been discussing today. The key will be to ensure that confidentiality wording is clear, proportionate, and limited to legitimate business interests, such as commercial information or settlement sums. Michael mentioned that NDAs are currently quite long. The restrictions in the bill are likely to mean that NDAs are going to get even longer. HR and managers should begin preparing now for a culture of greater openness. Reputational protection going forward is likely to depend less on NDAs and more on demonstrating fair, consistent processes. Training will be absolutely essential in this. Managers and HR teams will need to understand very clearly that using NDAs to restrict disclosures about discrimination or harassment will no longer be lawful once these provisions take effect. Now, notwithstanding all of this, I would reassure you that ultimately careful drafting and fair handling of complaints will still allow you to manage risk effectively within the new framework. There are also a few things for us all to watch out for with these new provisions. Some concern has been raised about unintended effects, particularly whether fewer cases will settle if employers can no longer rely on NDAs. While this is possible in theory, experience both abroad and in the sectors where tighter restrictions currently exist suggest it is unlikely to cause major disruption to settlement numbers. In Ireland and parts of the US, similar reforms have not significantly reduced settlement activity. Employers still ultimately value the certainty, cost saving, and closure that settlement provides, and those advantages remain unchanged. Also, confidentiality will not disappear altogether. Employers can still protect commercially sensitive data and the financial terms of an agreement. So generally, these reforms represent evolution rather than revolution. Confidentiality will continue to play a role, but in a narrower, more transparent and balanced way. Before we move on to take questions, I just wanted to signpost our Employment Rights Bill tracker to you. Today, we've been talking about NDAs and Clause 24 of the bill. That's just one of 28 reforms being introduced by the bill. Keeping up with the changes to the bill, the roadmap, the phased consultation and the phased implementation is a full-time job in itself. So to assist with this, we've developed a handy tracker tool covering all of the reforms in the bill, which is available on our website. Please use the QR code here to access that tracker. Now I'll hand back over to Michael and we'll pick up some questions.
Thanks, Nick. So, I mean, one of the questions which has cropped up is in relation to what happens if your grievance procedure, for example, contains confidentiality provisions whilst the grievance is being investigated, and whether or not those sort of provisions in policies and procedures are going to be caught by the protections set out, or the legislation set out in the Employment Rights Bill. And you know, that is quite an interesting question, and I guess ultimately we'll have to see how all of this comes out in implementation. But I think our position now would be, well, you need to look at whether you have a contractual policy or not, because I think the Employment Rights Bill really relates to contractual arrangements. And some sectors, you know, in the public sector or the education sector, there is more likelihood of a policy potentially being contractual. If your policy is contractual and it does contain some confidentiality provisions, then you might have to think about how that'll work in practice. You know, if it says that you won't talk about your grievance once you've raised it during the period of investigation, there's very good reasons for that. But the question would be, well, is it caught by these sort of provisions, and do we need to adapt that or not? I don't think it's entirely clear at the moment. Nick, I don't know if you've got any thoughts on that.
No, it's not. It's just not clear enough at the moment for us to settle either way, I don't think.
Yeah, and you know, one has to look at the proportionality of it and the importance of it. For example, if someone were to speak out, if that were to fundamentally undermine the investigation into a grievance, that would be one thing. If it were to have a peripheral or no effect at all, that would be another. So, you know, there's quite a lot of issues to consider. But as I say, I think if you've got some contractual policies, we may need to have a look at that in due course about how that operates in relation to these provisions. Good. So the next question was, what happens about historical agreements signed which have potentially silenced outrageous employee behaviour, outrageous in speech marks? Would this legislation be retrospective at all? Nick, have you got a response to that around the Employment Rights Bill?
Yeah, there's nothing within the bill to suggest that it will have retrospective effect, and so the position at the moment is that it won't have retrospective effect, and all agreements, including NDAs predating the bill coming into force and these particular provisions coming into force, will continue to be effective. They won't be voided. That could theoretically change with the regulations that are introduced alongside it, but there's been no indication so far that will happen.
Great, okay. Well, those are the two main questions I think I can see that have come up in the Q&A as we've gone along. So unless anything pops up in the next minute or so, I think we'll call an end to it there. It's a good succinct topic we've covered this morning. Managed to cover it a little bit quicker, 10 minutes or so quicker than normal. Thank you very much for attending. I think there will be a poll which comes around shortly. It'd be great if you could fill that in. And if there's any feedback or questions you want to raise with Nick or I separately, then you can easily access our email accounts and get in touch. So thank you very much for attending, and I look forward to seeing you at the next webinar.